What time you're on?
You know what?
No,
You
I'm
better-
just, I'm trying to get
Mr.
some
Cater,
understanding.
Mr. Cater, check yourself. You do not address me that way.
Yes,
Ever.
Woo, guys, I got a brutal one for you today. This courtroom explodes as an aggressive defendant pushes the judge too far and instantly gets shut down. The tension spikes and the attitude gets checked. Everything flips in seconds. You won't believe how fast control gets taken back. For non-stop courtroom drama like this, make sure to like and subscribe. Now let's jump into it.
What do you believe? Sorry. Like a picture at a baseball game. What do you believe? Sorry. Infinity Investment and Technology versus Willie Cater.
Good morning, Your Honor. Willie Case.
Good morning, Your Honor. Ron Ruark for the plaintiff.
All right. And where are we on this?
That's a bench trial this morning, Your Honor.
Have you guys resolved it or no?
We have not resolved it, Your Honor.
All right.
I'm asking for 1 week adjournment, Your Honor, because from my understanding, I'm not trying to, I ain't ignorant to the law or nothing, but the last work that I had got, it said pre-trial on it. And before Mr. Rourke here had got it, I guess he was out of town and he came and asked for adjournment like a day before. And then it went off into this one here. So when I called up here yesterday, the lady said, no, you have a bench trial today. And I'm like, no, the last paperwork I got in, it said pre-trial today.
When
But she
was
was-
that?
When we were supposed to come on the 10th. Mr. Rourke had
10th
of this month here, but I guess Mr. Rourke was out of town. And he the one that asked for the adjournment. He had called me, got in touch with me and said he's gonna ask for adjournment until the, because he was out of town and he wouldn't be in court on the 10th.
Your Honor, I have the notice to appear in front of me. It's dated October the 12th. It says for non-jury trial today at 9 o'clock.
I'm talking about the one before this one. I'm not talking about this
One
one. I'm
before
talking,
that.
yes, sir.
Mr. Cater.
Uh-huh.
One before that, I think says non-jury trial also.
No, it says pre,
I'm looking right at it. From the 10th, from September 29th. Says non-jury trial.
that we supposed to came on the 10th. It says pre-trial on my paper. Because that's what I
Where's
know.
the
I said,
paper that says pre-trial?
I don't have it on me, Your Honor.
Oh yeah, typical excuse. Oh, yeah, no, that's not what it said, but I can't prove it. Just take my word.
I don't have it at all.
Because if it came from the court, that didn't happen. Because
That's
I'm
one
looking
scheduled
at
for
the
the 10th.
copy.
I don't know if I do this one. I got in front of me.
I'm looking at the copy right here, September 29th that we issued it.
Mm-hmm.
It says non-jury trial, October 10th, 2023, 9 a.m.
Well, that's
The
this.
next sheet
Mhm.
is the stipulation in order to adjourn the trial from the 10th, and it is ordered that this adjourned until following time.
Yes, sir.
And then we set it for October 24th, 9 a.m. in person. That was the order I signed, and it says on there that the trial in this matter.
Oh, well,
will be
forgive me for
adjourned to
being-
that day. Hold on,
Forgive me,
because I got more. On October 12th, what's indicating the court then sent a notice, and that notice indicates that this is set for non-jury trial.
Only reason I asked that, Your Honor, is because my evidence is in my phone that's broke and it won't be back to tomorrow. Fix the screen, like everything I have in that phone from the conversations I didn't have with my landlord of all the repairs that have to be done to say, these repairs are not just coming up before, even though you ordered them about the repairs, and then she sent a repair guy over to fix a few little things. But the most important stuff that had to be fixed, the leaking since in the basement and the water coming down and leaking to where my son has all of his stuff downstairs in his little room. You know, all of that still has been unresolved. So they did come over there and did a doorknob, fixed the stair and all of that there, and sent the court the paper that the maintenance guy had done the work. But still, the majority of the work, it hasn't been done. The most important stuff, I could have lived with the doorknob and all of that, but the most important stuff, it's like there's no air or heat that gets upstairs to my house, period. My whole main floor will be like right now, the whole main floor is heated up. You go upstairs when that temperature drop, it's just like you standing outside still. In the summertime, whole main floor has air conditioning to it. You go upstairs, it's like you're outside in the sauna. And I have all
Mr.
of these
Cater.
conversations. Yes, sir.
Mr. Creator,
Yes, sir.
how come you haven't complied with the court's escrow order?
With the $1,200, because I had put 600 in Miss Linda's account. And then before I even put it in the court, and I worked for Ford and we're on strike. My plant, Michigan Assembly, was the first plant to go on strike. You know, so if I have to put something in escrow, I just ask Your Honor to give me 1 week to put it in escrow, but I'm asking just to have get my
I
evidence.
ordered escrow over a month ago.
For the 12, you said for the 1,200, am I correct? And I put 6 in her account, and I asked her, can I get it back to put it to the court? So she told me no, because it was already in their account. Because I had put it in when you had ordered the escrow. I put it in her account that day.
Your Honor, my client acknowledges a payment of $600.
Yeah,
The other $600 payment, that check bounced.
because it was $4 short.
Your Honor, Mr. Cater owes $14,100
I
in
don't think
rent.
that's an accurate number, Your
7
Honor.
months of rent. He hasn't paid since, he paid March pursuant to the last court order. He hasn't paid April through October, except for the $600, which he's been credited with.
Your client hasn't fixed nothing since April.
I would also point out, Your Honor.
You know, your
that-
client hasn't fixed the essential stuff.
Mr. Cater,
Yes, sir.
I listened to you.
Yes, sir.
You were not interrupted.
Yes, sir.
So the way it works here is when he's speaking, you will not interrupt. Am I
Yes,
clear?
sir.
Am I clear?
Yes, sir.
Your Honor, we've been litigating these matters, evictions. This is the third eviction since July of 2022. It wasn't until the eve of the trial in this case that Mr. Cater complained about any repairs that needed to be made. And now he's using that as an excuse not to pay his rent at the 11th hour. We're asking for a judgment of possession in the amount of $14,100, $160 in court costs, for total judgment of possession for $14,260.
Can I,
That's 7 months rent.
can I respond now, Your Honor?
And for the first 6 months of the rent, Your Honor, he said nothing about repairs that needed to be made.
These repairs has been talked about with being a landlord for a year now better. I mean, that's why I say I have all the evidence. I have the text. We have
Mr.
talked
Cater,
and she knows
Mr.
this.
Cater,
Yes, sir.
I'm not adjourning the trial. You guys will either work it out or we're gonna have a trial today. You haven't given me any reason to. You're telling me something shows that it is a pretrial notice. I have no
Okay,
pretrial notice.
What I'm asking, Your Honor, is that I get my evidence. They're in here with all their evidence, and she's in here with her lawyer. I can come in here and contradict everything he's saying. Because I can get it, I can show you, I can get it printed out. Only thing is my phone has broken, which I can't get it tomorrow. I didn't ask for the adjournment on the 10th. They did. I was ready because I had my phone at that point. You understand, Your Honor, to show you, Your Honor, that what I'm talking about is factual, is the truth.
Mr. Cater, had you complied with the escrow order, I may not have a problem. You have not complied with any order that I've issued here.
Your Honor, I could pay the money in escrow tomorrow. Guaranteed you. That's a guarantee. I'm on strike, Your Honor. Hey, we only getting between $400 something and $500 some dollars a week now. And that's
Mr. Cater, you were supposed to put the money in escrow prior to now.
And I gave her half of the money, put $600 in her account.
Then where's the other half?
I can have it to you tomorrow, Your Honor.
Well, you gave 600, but then
Yes.
600 that bounced, right?
Yeah, it was
So-
$4 short in the account.
Okay, but the $4 didn't get made up and given to her,
No,
right? Okay, then that was what, for September?
I'm leading up into October. Yes, sir.
And then I don't have October rent in escrow. And I'm all the way through October now.
Mhm.
So why would I adjourn this?
So I can show the court and Your Honor that I could put what I can in escrow tomorrow, Your Honor. How much they gave me, I probably have $1,100, who knows? But I'm just telling you, my evidence is pure. I understand that what she's saying, and the only way she sent the repair guy out there is because you ordered them to. Other than that, it wouldn't have been seen, because these repairs have been going on now for over a year, and this is what his client knows. I didn't just come in here and start
Cater.
making and asking up for
Mr. Cater.
repairs to be done.
Mr. Cater. We'll be having a trial today.
At what time, Your Honor?
You know what?
No,
You
I'm
better-
just, I'm
yeah,
trying to get
Mr.
some
Cater.
understanding.
Mr. Cater, check yourself. You do not address me that way.
Yes,
Ever, ever.
I just,
I'm gonna pass, no,
Mm.
don't ever.
okay,
I'm gonna pass the matter for a half an hour. That way you can figure out if you can get your evidence and you can figure
Not
out how
gonna
you're
be
gonna
able to get
conduct your, how you're going to.
I'm not gonna
Do
be-
not interrupt me, Mr. Cater.
Man, this guy's done nothing but interrupt the whole time. Ironic, because it's what I did.
I'm gonna handle some of these other matters. Figure out how to get your evidence, get it in here. And we're gonna have a trial.
we might as well go, we might as well just go ahead, Your Honor, because I'm not gonna have my phone out the shop until
Then
tomorrow.
maybe what you ought to do
You know,
is maybe you can go with counsel and try to arrange something and try to work it out. But we're having a trial today.
Your Honor, may I? I just put an offer of settlement on the record for the possession purposes only. I'm willing to cut the judgment possession in half down to $7,000 even. So if he only pays $7,000, he'll stay. He can put the other $7,000 into repairs if he wants to and bill my client. But that's our offer of settlement. I'll cut it in half for possession only.
You want time to think about that, Mr. Caden? What do you want me to do? What would be his redemption period?
He'd have to, today is what, the 24th?
Are you
Can I
giving
get
10
14
days?
I could give him 14 days.
yes, sir, I'll take that. You pay the 7,000
guys-
14 days.
There'll be no
You
court
guys-
costs added.
You guys write it up.
Okay,
I'll sign off on it. I'll
yes, sir.
call you back up when you have it written up and everybody's signed off.
I think I'll have to get a judgment of possession from the court, Your Honor, blank one.
Okay, there's probably some up front. I'm not in my courtroom. There's probably some up front. It's front counter.
All
All
right,
right, let me know when you're ready.
thanks,
you.
Your Honor.
Man, I couldn't imagine getting cocky with a judge and then demanding time to have a supposed broken phone and how he needs his evidence to disprove their evidence. Okay, bud. But you made good drama. I appreciate it. Speaking of that, if you like drama like this, make sure to like and subscribe to Daily Courtroom Drama, where we upload twice a day, and I'll see you on the next one.